Hey guys, this is Corey D. Silverstein from myadultattorney.com. Please check out my website, myadultattorney.com. Check out my new subscription platform for performers called Adult.Law. Of course, follow me on Twitter, social media, either My Adult Attorney or Corey D. Silverstein. And don't be a stranger. Thanks so much.
And when it comes to content, what's the legal definition of content?
Well, content can be content. It's not necessarily a legal definition, but ultimately content could be a video, it could be a picture, it could be videos, it could be a series of pictures. It's anything that two people create for for the purpose of it being something. So, you know, content can be videos, it can be pictures, it can be audio. Content can be audio. Content can be anything. Content can be artwork. It could be 1,000 different things. Content, for example, this interview we're doing right now is content.
For sake of discussion, I used to be a photographer. I did that for 20 years. But the minute I click that button, do I own the copyright?
Well, see, that's where things get a little bit tricky. So as a photographer, you are in the best position to claim copyrights. But what you have to look at is you have to look at what the relationship is. Say, for example, Dominic, you were my employee and you received a salary, and as part of your job was you were making content. No, you would not be the copyright holder. I would actually be the copyright holder, because in that sense, you were an employee. In an independent contractor relationship, it's a little bit different. In that case, you want to make sure that your photographer has what's known as a work for hire agreement.
Yes.
That would actually ensure that me saying, assuming I hired someone, but in the case where you have none of that in place, then ultimately the person holding the camera creating the footage is generally the copyright holder. Or can argue that they're the copyright holder.
If I use your camera, is it still my copyright?
Again, I would say that even if you're using my camera, you took the picture, I would say that there's still an argument there that you would be the copyright holder. So what I always tell people to do is don't take any chances. It is so easy to put this in writing. Get it in writing before anyone takes the phone, before you borrow the person's phone, before you use your own phone. Get it in writing. It will save you.
And how legal, or how much in a courtroom will a verbal approval hold up as opposed to a written release?
Worthless. Verbal is worthless, because now you're talking about a he said, she said situation. Good luck trying to prove it. And work for hire agreements can't be verbal anyway. They have to be in writing. So if you don't have an understanding in writing and all you've got is oral representations, and you call me, chances are I'm not going to take your case.
And from a production perspective, you just touched on it, but you do a production tomorrow. You hire me to take photos and you pay me $150. There's nothing written between us. Do I have the right to use that material to go back to whatever I just shot and get my own paperwork?
Oh, that's a complicated question, because from a copyright perspective, you might have some rights. But in terms of the models that you actually shot, if you don't have the proper model release documentation, sure, great, you have the copyright, but you can't do anything with it. If you can't monetize it, if you can't exploit it, because you don't have the proper agreements giving you permission from the performers in there to use their name and likeness to display their content, then you just have a copyright and you got nothing else. And that's one of those areas where people always get confused. They think that just because you have the copyright, you then have it all. That's not correct at all.
For sake of discussion, if I go back to the model and get paperwork, am I then covered?
Hey, listen, as a lawyer, especially when it's being recorded right now, I can never recommend that you take the position of going back and backdating and back creating paperwork. I think that's a mistake. And I think it creates a lot of potential issues in terms of a potential intellectual property fight. So the rule of thumb is get it when you make it.
A lot of adult material is, what's a nice way to say it? It's a lot of the paperwork is questionable, or there's no paperwork. When I say that, if I go to shoot for a company and we're on location, there are no location releases, there are no shooting permits, there are nothing.
Yep.
How does that validate the entire production or invalidate it?
It's crap, and it causes problems down the road. And it's one of the things that frustrates me, and it's one of the reasons why I created Adult.Law. I mean, I've represented larger production companies, I've represented websites, you name it, I've represented in this business. But from what's happened with COVID is that so many performers have gone into business for themselves, and they don't have everything ready to go. they're not in a position, they don't realize how important this is until, for example, one of my clients, shortly after COVID started, she started shooting with her roommate and they didn't sign anything. And guess what happened to the relationship? The relationship fell apart, and now they're in a horrendous battle over who should get the rights to use the content and so forth. They have no paperwork. Neither of them have any rights to use the content because they're both in it. So, it is such an easy problem to fix. But again, it's like, I get it. I can understand that a lot of people are hesitant because they're like, look, we don't want to spend the money on lawyers because we just don't want to. But when you come to me in 6 months from now and say, now I have a big problem and I'm being sued, and now you do have to put up that $25,000, $35,000 retainer, like, shit, I wish I'd gone and signed up for Adult.Law, or I wish I'd reached out to Corey, because for a very small sum, these are all easy things that can be fixed so that any producer out there, any performer out there can create content safely.
Okay, from either side of the coin, when I say that, the performer or the production company, does the fact that there is no shooting releases, shooting permits, shooting anything invalidate the model release she signs?
Well, if she signed the model release, now it's different. If she signs the model release and the producer has the model release and the proper 2357 documents, then no, in that point, the content's fine to use. There wouldn't be anything wrong with
that. When you join OnlyFans, this fans, and everybody else's fans at this point, when you go through the process, one of the questions or what do you call it, the area of agreement, I don't know the right word, is that you have paperwork, 2257 and a model release for everything that you post.
Correct.
Does that mean that, for sake of discussion, you and I are sitting in a pizzeria and we take a photograph together and we happen to catch a patron behind us or on the sides of us? Am I expected to have a model release for that individual behind me?
It depends how you're going to use it. If you're going to use it to commercialize the image, there's a good chance, yeah, you might have to have a release from them. But then you start getting into, categories of what constitutes fair use and what categories is all of the exceptions to intellectual property violations. And that's, again, that'd probably take me about a week and a half worth of you and me talking to get through all that. But the rule of thumb that I always say, if you don't have permission from someone, do not post their content. It's very simple. If you go by that rule of thumb, you will be fine. If you don't, well, then there's always that chance.
Is that the same for you and I are friends and we take a selfie together and I post a selfie?
I think that's a little bit different, because if we posted a selfie, we wouldn't be doing it for a commercial purpose. We'd really be, you take a selfie of you and me on Facebook, I think it'd be very hard it would be very difficult for me to turn around and sue you, So I don't think that's the greatest example in the world. But what I can tell you is that if you happen to catch a stranger in one of your pictures and you put it up on your adult website, you better hope to God that you have a release, because that person might not want to be part of that adult website. So again, to me, it's like rule of thumb, get the damn signatures or blur the person out.
For sake of discussion, you take a picture, you and I take a picture and I put it on OnlyFans. And we're buddies and we hang out and we have a falling out. Can you then come after me?
Who took the picture?
I did, for sake of discussion.
Well, you couldn't argue DMCA. I mean, you could, since if you took the picture, you're the copyright holder, so I don't have a DMCA complaint. Now, could I complain that you have me on a website that has pornography and it's putting me in a bad light, whatever? Yeah, I could come up with something.
And one of the popular forms of content that's shot, you touched on it earlier, but is POV content, point of view.
Yeah.
I personally have shot a bunch of content with performers who use their civilian boyfriends. And when I say civilian boyfriend, someone who's not in the business. Does that performer need a model release in a 2257 from the individual?
Absolutely. Absolutely. 120%. Everyone needs to have signed documentation. If there's any person in a shoot that doesn't have signed documentation, it is being created irresponsibly and dangerously.
Another two-part question about content. Can that individual come back and sue you or sue OnlyFans?
Not really OnlyFans. See, the thing with platforms is that platforms have such things to protect them, such as the DMCA. They have things to protect them, such as Section 230. There are various different laws that actually protect platforms. The reason for that is, let's look at it as even bigger perspective. if let's say Amazon web hosting, which I believe is now the largest web host in the world, if Amazon was actually legally responsible for every piece of content that's on one of their servers, there would be no Amazon web hosting. No one in their right mind would be a web host. OnlyFans is very much the same way, or any of those are their platforms, and they're operating legally, they're operating within the confines of the law, and they're operating because they should be able to operate that way. They should be able to act as a platform. They're not the ones posting the content. They're just a platform that allows it. So I look at them the same way that I do a web host. And so I don't see them as being a potential issue. I see someone as potentially posting something, such as, revenge porn, something like that. That sort of stuff is intolerable in this society. And those people should be chased, prosecuted, and sued as far as the law will go.
And if an individual posts third-party content on OnlyFans, can the copyright holder go? I think you just mentioned it, but they have no recourse to go after OnlyFans. They can only mention the person who posted it.
It would depend because assuming that the person who owns the copyright files a DMCA service with whatever service, it could be YouTube. Let's use YouTube.
Right.
If YouTube follows what's required under the DMCA, then they would be immune from potential financial damages under the safe harbor provision of the DMCA. So what it comes down to is responsible service providers comply with the DMCA. They do what they're supposed to do, and that's why you don't find them, having problems with content. Frankly, if the DMCA didn't exist, I don't think YouTube would exist. I really don't.
And would the copyright holder be able to sue the person who posted the material on Judy Smith's page on OnlyFans for lost income or lost?
Not lost income, but they could sue for copyright infringement, assuming that they actually had a registered copyright, because the U.S. Supreme Court ruled, I say recently, but within the last couple of years, that the process, you can't go after someone for U.S. copyright infringement without actually having the copyright being finally approved and granted by the U.S. Copyright Office. The way it used to work is you could have an application pending and still proceed with the suit, but now it has to be completely finalized before you can actually file your suit.
Do lawyers ever get brushback or harassment from people when you're trying to defend your client in the adult industry?
Yeah, we've had, in my office specifically, we've had threats. We've had threats of violence. We've gotten letters from people who are asking me like how I can do what I do, and et cetera, et cetera. And as far as I'm concerned, I took an oath a long time ago, and I committed my career to protecting freedom of speech and the First Amendment. And I'm right there side by side in the war with every person out there that wants to distribute content. I don't want to be part of a world where you're not allowed to show what you want to show. That's not the world that I signed up for. And so what goes with the territory is someone who disagrees with me, wants to, threaten me or any nonsense like that, knock yourself out. It's not going to change my decision, and I'm not going to stop fighting, and I'm not going to change my mind because, you're too immature, narrow-minded to, understand what the First Amendment truly is about.
The Ron Jeremy case, does that ultimately come down to consent?
Well, which one is the problem? Ron Jeremy has a lot of cases now. It's not just one case anymore. And there's a lot of different allegations, and there's civil aspects and criminal aspects to it. That situation is going to play out in court. I have absolutely no idea where that case is going to end up. I don't even, your guess is as good as mine with that one. But what I can tell you is that from what my understanding is, as the cases move forward, they've found more witnesses and they've found more people who, have allegations to make. So that's really, that's a tough one. That is going to be a really, really difficult case for everyone. It's going to be a difficult case for the prosecutor. It's going to be a difficult case for the defense. It's going to be a very difficult case for the judge. It's going to be an extremely difficult case for all of the victims. So it's, in my humble opinion, everyone in that case has already lost. But again, as I said before, there is no place in this industry for people who engage in behavior. There's no place for that. There's consent or there's not consent. There's no gray line. There's no, well, maybe it was a yet. No, it's consent or non-consent. That's it. There's no gray line. And anyone who falls into that non-consent category should be absolutely held accountable.
A two-part question. You go to a convention, an appearance, and you meet one of your stars,
Mm-hmm.
and she's been very suggestive and very whatever online. You accidentally touch her butt. Is that non-consensual? Is that okay?
It's non-consent. Unless that performer said to you, you can touch my butt or you can do this, that's non-consent. And that's not appropriate anyway. That's just not gentlemanly. That's just you don't behave like that. That's not how people in this business are supposed to. You don't just go up to girls, start touching them, without their consent. You don't do that anywhere in the world, let alone this business. So no, you don't. No, it doesn't matter if you guys were flirting on Twitter. If you walk up to someone and grab her ass without her consent, you grab their ass without consent.
Is that a criminal act?
Absolutely. Could absolutely be bad. Absolutely. Absolutely.
I've gone and seen 10 of my favorite performers.
Mm-hmm.
8 of them have let me grab their butt.
Mm-hmm.
In my head, I'm thinking everybody thinks it's okay.
Mm-hmm.
Is there any legal basis for you to take that argument and said, well, 8 said it was okay, so the 9th one?
I don't care if there was 10 million of them and 10 million of them said it's okay, but that one person didn't. That one person has every right to say no. That one person has every right to protect his or her own body, and that one person has every right to consent before anyone touching them. And so the answer to that question is, I don't care how many other people might do it. The answer is still no.
And for sake of discussion, Judy Smith changes her stage name to Judy Jones.
Mm-hmm.
Can anybody say it's a different person?
Well, it wouldn't be a different person, but it's a completely different. It's like a brand starting from scratch. It's a totally different. If Jenna Jameson started running around and calling herself Carly Blue, it's a completely different brand.
But if you own the second name, could you almost tell the first one to stop using it because it looks like the new one?
No. Well, if you have the rights to it, now you're talking about trademark infringement. If someone's like that, if someone goes, for example, and registers, you can talk about Playboy. If someone goes off and goes and registers Playboys, .com, Playboy is going to have a case for trademark infringement, and they're going to go after them simply because they changed one letter of the domain. Doesn't mean that the brand holder can't go after them, and they will.
We're doing a production tomorrow. For sake of discussion, it's a boy-girl scene, 3 positions and a pop. Mm-hmm. We have the discussion before the shooting begins of do's and don'ts. Mm-hmm. And we agree there's no spanking, no slapping, no spitting, mm-hmm. for sake of discussion. We start rolling, and the first thing you do is slap the person. Mm-hmm. Is that a criminal thing? If they violated the law?
It absolutely could be. And if I were every producer, I'd be reading and following the Girls Do Porn case and paying very close attention to what's going on in that case, because there are a lot of lessons that are going to be learned from the allegations, guilty pleas, and proceedings in that case. And this is one of the reasons why I always tell people, have that camera running. There should be another camera in a shoot that's always running, that's recording the entire interaction between producer and model performers, so that if anything ever comes into question as to what was clear or wasn't clear. The other thing I always insist on my producers do is you should have a script. You should be going through a series of questions on camera, both before and after the scene, to make sure that everything went according to plan. But if it's made clear that an individual is not to be slapped, that's the example you came up with, and that's the first thing that happens, I would say that I would consider that a battery.
Is there any possibility there can be any misinterpretation in that? A slap versus, I don't know, a spank, a hit.
I think that if there's any area, and that if that happens, then you're shooting with the wrong producer, because a responsible, professional producer, there is no little line that someone could mistake in a slap for a handshake or what have you. A responsible producer will never put a performer into that sort of circumstance. And if they do, they should not be part of this industry. And frankly, they should be looked at for potential criminal charges. There's no place for that in this industry.
Assuming the person feels she's been violated, how many people within that production are responsible or guilty? Is the cameraman guilty? Is the photographer? Is the director? The
No,
producer?
I would say the individual that actually performed the act that was not consented to would be the person that should be charged. So if someone says to a co um, performer in the video, you know, do not do this to me, and that person does it, that person's done it. I don't think the person holding the camera is ultimately responsible for that. But again, there's a huge difference between a responsible production and a irresponsible, you know, person who claims to be a content producer but is anything or even anything even close to it. There are content producers out there that have impeccable reputations that have spent their careers building that impeccable reputation because they treat all the performers with dignity, respect, professional, no different than it would if they were on the set of the new Mission Impossible scene. That's how a production is supposed to take place.
Would you agree, disagree? We're in a society where they tend to believe the performer more than they tend to believe the producer, regardless of what proof the producer brings forward?
Not really. I just think we're in a society now that because of social media, there's a lot that you have a lot more, there's easier access for people that want to claim that something happened to them, whether it be true or not. They have that ability now to speak out to the world. I always encourage people that if something has happened to you, to speak out and to use every form of communication you can to speak out. The dangers with that, though, is of course there are some people out there that will make false accusations because they want to be famous or they want to make money or what have you. But in no way, and I got to make that clear, in no way should any person who ever feels that they were mistreated, violated, what have you, they should never feel that they should be silenced. They should always speak up, always.
A person who feels they've been wrongly accused, what are they suing the accuser for? Is it defamation?
Yeah, they turn around and typically they would sue for defamation. Yeah.
And they have to prove that what she said 100% is wrong?
They have to prove that the statement was untrue when it was made.
Does it have to be a specific thing where they said it, or can they show examples of other people have made the accusation, or you've accused other people of doing the same thing?
That would become a evidentiary issue at a trial as to whether or not a judge would allow incidents from other incidents to be admissible. That's a very difficult evidentiary question that's a very, very difficult question to answer. And it doesn't really have a definitive answer because I think different judges would rule on it differently.
Have you ever had an issue where you've met a client or been introduced to some potential client and she's been so badly burned, but there's nothing you can do for her legally?
Listening to another human being is always something legally that you can do for someone. Oftentimes people are ignored simply because for various different reasons. People don't think that they have money. People don't think that they're telling the truth, what have you. I don't look at it that way. Every person should have the right and the ability to tell their story, and then so that I can analyze the facts and tell them whether they have a case or not. So, have I had to tell people that I'm sorry you don't have a case for different reasons? Sure. Some people come because it took too long for them to come to me. They come to me with a civil case that the statute of limitations expired 15 years ago. That's a part of the business, unfortunately. But everyone has a right. Everyone has the ability to at any time, pick up the phone and have someone listen to them.
If people want to reach out to Adult.Law about possibly having you represent them, can you give them anything they need, any preparation they need to have in advance, maybe paperwork ready for you, anything?
Nothing. What I always tell people, though, is if you think you got a legal dispute coming, the best thing you can do is create yourself a nice little folder on your computer and keep everything. Keep everything. Every time you talk to someone, keep them. Don't delete your text messages. Don't delete your tweets. Save everything. And then so when you come to me for me to analyze your case, I'll be able to look at the whole picture. Because for any lawyer gets frustrated if you have to analyze a case piece by piece by piece. It's very difficult. But if you come to a lawyer with the full picture, it becomes much easier to analyze the legal issues involved.